Sara is Director of the International Bar Association. So this is a chance to build on some of the themes already outlined by Richard and Stephen this morning. So we're going to reflect on professional ethics, the rule of law, but we want to specifically question what the regulator's role is in restoring the trust in legal services, which Lee articulated so brilliantly for us. And we've already had that question posed today. So let me hand over to you. And I know you want to bring your panel up as well.
Yes, thank you very much for the introduction, and lovely to see so many of you here today. And obviously a huge thanks to Lee for your contribution just now. It's extremely moving and I think reminds us all of the importance of events such as these in trying to bring the legal profession into sharp focus and to improve it as much as we can. Now, I'd like to bring up my panel, if I may. We are one short. I'll explain in a moment, but we've got Tetyana and we've got Sophie and Charlie. Thank you very much. Take a seat. Now, excuse me, I've got a funny throat, so if everyone wants to get any water, then please take a moment to do so. We have a very short period of time to speak about an enormous issue. I mean, huge. So we've been given 45 minutes. I'm very conscious that we are running over. So I'll do my utmost to try and keep to that. But, you know, that's not to say that these issues shouldn't be revisited on subsequent occasions during the afternoon and, of course, during the break. So if anyone wants to come and speak with me and our panel members about the things that we are doing to try and address some of these challenges, then please do come and seek us out. So once again, thank you for today. I want to go straight into a question. I don't want to give the bios, forgive me for that, but it takes another few moments of our time and you can all read. So I'm assuming. So I really want to go into, having just heard as we have from Richard, Stephen and Lee in relation to a particularly egregious example of lawyer behaviour. I'd like to just ask really to all panel members, whoever wants to go first, is the post office scandal a one-off? Do we think it's just a terrible example of something bad that's happened? Or do we really believe that most lawyers do observe ethical standards in the way that they practice law, whatever area they're practicing it in? So it's not an easy question. Can I start first perhaps with Tetyana? You're a barrister. You're working in these issues.
Thank you. I mean, sadly, I don't think it is a one-off. It is one that has captured the public right now, but there are many more that are boiling underneath. I mean, just in the last couple of months, there have been two huge decisions by the commercial court about sort of the standard of fraud and bribery in arbitrations, for instance, where lawyers have been involved. And this is where the question of independence comes up and the correlation of pay to how much you question your client. One of the cases where the government of Nigeria was subject to a huge billion-dollar award, which would have been life-changing for the Nigerian people. And the commercial court found that that entire arbitral award was obtained by sort of bribery and fraud, including on behalf of the members of the legal profession. So, and that raises issues of what are we doing as members of the legal profession? And I should add that actually the sort of questions, the ethical dilemmas that members of the legal profession were facing in that case were not the tricky ones that you would find in an exam question as a student. They were very simple ones. For instance, should I be questioning what my client is doing, sending me confidential documents belonging to the other side? Yeah. And should I be questioning the fees that I might potentially receive?
Well, fees is a huge issue, particularly in corporate practice, which creates the challenge profit versus client versus humanity, as we've already heard. But thinking then in relation to a climate question, we have Charlie here, and I'm interested to know your thoughts on that. How do you think lawyers are generally operating within the ethical arena?
Thank you, Sarah. Well, I do actually approach this from a particular angle, but I'm not going to talk about the climate crisis now, so you can take a breath of relief for that. But what I want to talk about is SLAP, strategic lawsuits against public participation. It's a particular angle which is and a problem which is highlighted by the post office scandal. But I just wanted to identify precisely what the problem is there. What we've seen, obviously, with the post office scandal is justice delayed and accountability blocked time and time again. So SLAPPs, for those who don't know, are a form of abusive lawsuit which seek to block accountability through intimidation and harassment. And we've seen various different instances of this in relation to the post office scandal. We saw, for example, legal threats being issued against BBC Panorama. We saw legal threats being issued against Ian Henderson from the Second Sight, who was also threatened. We saw without prejudice letters being issued, unilaterally imposing this duty of confidentiality on people who might otherwise have discussed potential settlement agreements. And in answer to the question, sorry to give that background, but I think it's important. No, this is in no way an isolated case. In fact, I'd go further. If you look at any high-profile example of an abuse of power which is exposed, invariably preceding that exposure, you will find a pattern of legal intimidation and abuse of lawsuits being filed. This is a systemic issue. And just to think about that question about the conduct of lawyers, yes, perhaps it is the case that the majority of lawyers do maintain high standards of ethics. Because in the context of SLAPPs, what we see are the same law firms and the same lawyers popping up time and time again. And having worked on SLAPPs in Europe, I sit on the steering committee of the Coalition Against SLAPPs in Europe, I can tell you there is nothing comparable to the UK in Europe in that respect. There is in the US. We do see these belligerent lawyers inevitably gravitating towards Donald Trump, I should say. But we do see these lawyers appearing in the same SLAPPs again and again and again. But in Europe, it's only in the UK that you see this pattern where with the same lawyers, the same law firms appearing again and again. And that is, I'm afraid, a cultural question, which I'm very pleased to be exploring with you today.
Sophie, you've had experience and you've spoken a lot about NDAs, which we know, non-disclosure agreements, which we know can have both value, but also create significant harm and difficulty for individuals. Can you talk to us about the ethics that you're perceiving around how your lawyers are using those and where there are scenarios of perhaps unfairness?
Certainly. I mean, I come from an intellectual property commercial background, and so I'm very used to using them constructively to protect information and give value to that information. So the best use of an NDA. I then started acting for the Personal Managers Association, which represents 250 theatrical and film agents in the country, which actually translates to 50,000 actors. And I was shocked, absolutely, the disgraceful behavior of the use of NDAs. They're now not brought in after the offence. So Harvey Weinstein might come around with the lawyers the next morning. They're done before the actor goes into casting. So the actor turns up at the door, might be 17, 18 years old, sign this or you don't get an audition. And they contain, it's preemptive. They don't even need to clear up with the lawyers afterwards now. Brilliant. So they will contain indemnities. They will contain transfers of intellectual property. They will contain data protection issues, probably AI scanning. They take lorries on set to scan actors' bodies without telling them. And this then also translates actually into the contracting process in the entertainment industry, where I've had instances of actors being locked in a room and being made to sign documents that they can't read, they don't understand because they're American, first of all, and then made to hold up the contract and have a photograph taken of them with a smile on their face.
With a lawyer present in the room in
Nope.
that scenario, so no
Nope.
lawyer,
Nope.
just the company. in
No,
that
what they
sense.
do then, they send in junior production assistants who are very, very nice to go and do the dirty work. And there are 2 or 3 firms of solicitors that are right at the heart of this and act for and it's the SVODs, which is I mustn't say any names. You all have subscriptions, okay, I'm just saying. And the actors act for all of them. The lawyers act for all of them, and it's endemic. Yeah, so that makes me very angry, which actually, as a lawyer, I don't always find helpful.
What's been interesting in my experience, and I've been working internationally on these issues, and one of the things that lawyers often say, and I'm interested in all of your views again on this, is that it's for government to make the law. The lawyers just have to apply the law. They advise their clients accordingly, and that's really their job. And that's part of what the codes of conduct in some of the jurisdictions will be effectively saying is the first and foremost role of a lawyer. So you advise your clients, their best interests go first, and you do it within the confines of the law. So what is legal and what is right? And there is no question that we should supplant morality or our individual thoughts around good and bad that sits within that. Now, all of you have encountered these different scenarios which you've described, and all of them, let's assume that they are operating within the law, within what the law allows. How do you think that a lawyer should be thinking about the law in this context? Should we just simply apply black and white letter of the law, operating like plumbers, as I know Stephen says, as essential, are we technicians, or do we have something more to offer than that? Who would like to go first? Tetyana, perhaps.
I'm happy to go first. I mean, I think ethical standards are incredibly fascinating, and I've been a member of both professions. I was a solicitor and then a barrister, and also an academic. And ethics is what absolutely fascinates me. I mean, we have this concept of integrity, and both solicitors and barristers, and I think members of other professions, have to act with integrity. And that is actually used to express a higher standard, which a society expects of members of legal profession. And so I think my initial reaction is that as members of legal profession, yes, we have to give advice within the confines of the law, but integrity requires slightly more than simply following this strict black and white letter of the law, because you could be advising the client to be acting within the confines of the law. And one example could be, tax avoidance, evasions and sanctions. That's another popular issue right now. You could be advising the client within the confines of the law, but there comes a point where you have to think, is this something, does it pass the smell test? That's what I always have to ask myself. Is this something that I am comfortable doing? And the moment you get uncomfortable, you have to ask yourself why. And it would inevitably be this issue of ethics. Is it ethical?
I think that's the question though here, isn't it? Is the smell test the same for everyone? Because it absolutely isn't. In my experience, even within one country, we have lawyers who very much think differently, but certainly the cultural differences are enormous for us to try and overcome. Charlie, did you have any thoughts on that?
Yeah, absolutely. I mean, I think that even in the UK, and in the UK, there's a lot of emphasis on the obligations that a lawyer has to their client. I think that is a product of the adversarial system we have. But even in the UK, there is an overriding obligation that the lawyer has to the court, to the rule of law. And it was Richard Moorhead, actually, who said that lawyers are agents of the rule of law. I think that's a really good way of putting it. And so many of the abusive tactics we see are a subversion of that. And they are, and certainly when we're talking about slaps and we're talking about lawsuits which are intended to harass and to intimidate, lawsuits which have that ancillary improper purpose, those immediately come to tension with the rule of law. And in that case, I think a lot of what we're seeing in England and Wales is symptomatic of a failure to attach appropriate value to those obligations.
You want to comment on that, Sophie?
Yes, I mean, it's interesting because I'm very analytical with contracts. An agreement should mean that. It should be an agreement. If you're not agreeing, there's not a contract. So a lot of these NDAs are not enforceable. So it's not like they're even misusing the law. They're hiding it in plain sight. It is just pure bullying because you've got lawyers on your side. That's not even law. That's just bullying people. And that's what makes me so angry. When you do turn around, which I have done, I've used the SRA rules. I gave the agents all a sort of crib sheet, say, send this back. This is the law. We want to protect your confidential information. We don't actually know what it is. And by the way, your document is unenforceable. We see, and here's a link to the SRA. And a number of them came back and said, we don't accept that. I was like, fine, the sky is blue, don't accept that, the sky is falling, and we have made a difference. But I think law can help the individual, so it used at its best, you fight back with the clarity of law and individual. I know that pie in the sky, some days I think it works, some days I think it doesn't, but I think you need to look at both sides, because the lawyers in the middle are not doing their clients any service either, because the clients that don't actually have enforceable contracts.
Yeah. And what do we think the regulator's role needs to be in this space? I mean, that's after all one of the key reasons for today. I mean, how do the regulators operate more effectively with this regard? Because the SRA warning notices, the guidance that they've issued, I mean, that's a good start. But do any of you have suggestions on greater efforts that ought to be made, or things that the regulators need to do? Throw that open. Whoever wishes.
I thought visibility. I've been thinking about this, and it was referenced earlier about you know, the lawyers in the post office, I would like to hear that they are being looked into.
Yeah.
I mean, I do think there's this issue where lawyers are very much like the hired guns. They're
Yeah.
slightly in the shadows. The executives actually often take the fall, and the lawyers somehow just seem to disappear.
Yeah.
You don't see the lawyers up on the stand. And I think that that sends quite a difficult and bad message. And I also feel, I'm just going to get this thing in here, that the way the government and certain MPs talk about the law, some of whom are KCs themselves, sends a message straight back down the system that don't respect the court, you know, lack of respect for courts and law itself is acceptable.
Just comment on that and just say a couple of things. I think the first thing is that we've been having some interesting discussions already about you know, the need for regulatory change as opposed to cultural change, and what we haven't really spoken about is how the two do interact in that way. So especially I think in the legal profession, regulatory change or guidance from regulatory bodies can really help shape culture in a positive way. And I think part of that is because it does help set that culture. I mean, in the case of the legal profession, what the regulators say will then inform, you know, modules on legal ethics, which will then be the foundation for the way that lawyers think about their job. So I do think that there's part of that, but also there is this point which has already come up today, which is about providing greater clarity in the face of conflicting rights and duties. That's something which the SRA has started to do over the last few years in relation to SLAPs. There's a long way to go though, because much of this guidance still has ambiguity in key parts. And I think only really when it comes to the application of those codes of court conduct in relation to specific cases will we see that cultural change come into being, because then lawyers, I think, will have that greater clarity about how to navigate those conflicts.
Yeah.
May I just come back, because I mean, I act in my professional life as an advocate, I act for and against regulators. And we've heard from the SRA, and I think there is sufficient regulation and guidance, in fact. But what there isn't, I think, is there isn't visibility of the type of work that's done by the regulators. Because what you don't see is that the SRA, and they have said it on their website, they are already investigating the conduct of the lawyers involved in the post office inquiry. They're investigating this conduct. That investigation takes time. And that is because a regulator has a lot of responsibility to members of the public, but also to members of the profession they're investigating to get things right. They can't just go on the say-so of what's said in the inquiry. They've got to analyse all the evidence for themselves. So imagine the inquiry going on for years and years, and the SRA effectively are doing underneath all of that their own inquiry, and they're looking at even more documents. So they have their own powers of investigation. So I think in terms of what the regulation can do, I think we have good regulation at the bar. I think we have a fantastic regulator at the solicitors, but perhaps what the regulators need to do is to make their work more visible, to explain to the public what is it that they do and why the investigations have to take time. Because if you bring in a prosecution which is not ready, and I've been an advocate where the SRA will come to me with papers and I'll say, okay, well, we haven't got this document. Why have we not asked for it? We haven't got that. If you come to prosecute with a half-cooked case, you're not going to get the result that the members of the public deserve. And I think it's important to realize that. I think that's what I'll say. And in terms of cultural versus regulatory change, I actually think we need a cultural change rather than regulatory change. Cultural change in law firms where juniors have access to more experienced colleagues with whom they can raise issues. Because I'm afraid to say that once you've been in a law firm for 10, 20 years, you just think, oh, this is how it's always been done. But where you do have questions and where your ethical training comes up is when you're 1, 2, 3 years there. And you think, this isn't right. And to be able to call, perhaps even not just to speak to a colleague, but to be able to call your regulator and say, I'm not sure that what's happening is right. That's another thing. And that could encourage cultural change.
Yeah, no, absolutely. I couldn't agree more. I personally think that the regulation is only one piece, and it's very easy to blame the regulators because that's the obvious kind of fallback, but actually how much responsibility should be taken from within a firm, a practice, a chambers, wherever you're practicing from, in order to set the tone. And this is a really important question that was raised earlier in relation to this question of profit and what drives many law firms, and in fact this is essential to a point, of course, is a question of business survival. And it's an interesting question around whether a lawyer needs to be a brand or a client cheerleader in order to then bring in the clients that bring in the revenue stream, which is essential to survival and then essential to competition with your immediate compared tier law firms. So I don't know if here anyone else thinks that there needs to be a real push from the leadership of these sorts of firms, whatever the size, that actually profit can never come at the expense of the reputation of the profession and the behavior of the profession that the public, through the social license that they give lawyers to operate, should be deserving of. Does anyone have any thoughts on that position?
Yeah, I mean, a lot of it is about the business model which is being pursued by these law firms. I mean, inevitably, where you get people, you get bullies. I mean, what we see in many parts of Europe and indeed the world is you'll get thugs, whether it's like kleptocrats, sexual offenders, just gangsters, who will use the legal system as one of a number of different tools to bully people into silence. You see that around the place. And so where you have bullies, they will always be attracted to the legal system as a means of trying to shut down their target. The question is whether or not the law firm is going to facilitate or is going to build a model which is based around facilitating that type of abuse. And you know, I think that if you're at a point where you feel you need to build that sort of client base, then I would seriously question the business model you're pursuing. And what I would say to law firms which are facilitating that type of abuse is I do think things are changing. I do think we're starting to see that cultural change. It's not just in the movement of legal regulators to start build greater clarity in this area. It's also the fact that we have seen this mobilization of civil society groups against slaps, against other forms of legal abuse. And I think, and I hope, it will become harder to build that type of business model, which is built around that type of abuse.
I think there's a problem in-house, I think, because they pay your wage directly. And in the film industry, it now comes under the guise of business affairs, which sounds really creepy. But so talking to the agents, I say, are you dealing with a lawyer? Well, I don't know if I was dealing with a lawyer or not. They're in business affairs. And I'd say, I'm pretty sure they will have been a lawyer. So they don't even know if they're dealing with a lawyer. The access of agents and actors because of the expense to lawyers is minimal. But I think there is this idea that, and I think it did start in the 80s. We had a discussion this morning about this, about lawyers becoming businessmen. Mm-hmm. And I think that is very risky and dangerous when it goes in-house. And someone mentioned on another discussion about lawyers being the conscience of the company. Should they be? And personally, I actually think they should. But I think it becomes very difficult with the pressures they have in-house and that blurring of the lines.
Jana?
I think the biggest issue is this issue of independence, and it is most stark when you're dealing with in-house lawyers, and I welcome the additional guidance on that from the SRA for sure. In terms of the business models, I think what I see actually is moving away from the business model of making a lot of money using sort of unethical causes, because actually it's very hard to attract, to recruit people into that sort of law firm, because young students don't tend to go into law because they want to hurt people. They go into law because they believe they can make a change and a difference in this world. And so when you want to attract the best young minds, you would want to make sure that actually your model it isn't something you're not promoting taking advantage of people. So your business model has to take account of recruitment and the stream of young lawyers who come through. And more I see law firms actually taking on amazing pro bono projects and writing about them with as much enthusiasm as about their big billion-pound deals, because that's what attracts, I think, both new lawyers, but also I think it attracts clients. I think there is just generally even in the investment world, there's more emphasis on sort of greener practices and more just kind of more ethical practices. And I think that's what's going to attract people more and more. So I think the model of earning a lot of money using unethical practices is hopefully dying.
I think this is a moment here. I'm just going to double check with the organisers. Is it right there's 20 minutes left? Because I've got two different timing structures here, and I'm very conscious of bringing the audience in for questions. I imagine there will be a lot of questions here.
You can probably not hear me. I'm going to suggest we finish at 10 past.
Okay.
So
I've got 15 minutes.
So you've got
Yeah.
15 minutes. I'm going to suggest we finish on the dot at 10 past, and we'll get you back here then at 1/2 past. So we're going to reduce your break to 20 minutes, I'm afraid, but I know you want to hear from each other and everyone. So Sara, back to you.
I mean, 15 minutes, I think we should open up to questions because I think there's going to be a lot to say. So the gentleman at the back, I think, had his hand up first. I saw that first.
Thank you.
If you
Good
could
morning.
keep it short. Thank you very much.
My name is Jeremy Barton. I'm an in-house counsel, actually in the accounting profession. So I'm regulated in theory by both the, well, I am by the SRA and the ICAW and FRC. My question / comment is in terms of learnings across professions. The legal profession isn't the first profession to be confronted with ethical challenges. In the accounting profession, there are a number of things which resonate for lawyers. Independence of auditors. If you're an auditor and you stand up to the CEO and you resign from a client, the regulations, in fact, the statute requires that there's transparency about that as to why you resign. You can also look at experiences in other professions, even the medical profession, about how they handle ethical issues. For me, it's both those structural questions as to how the regulator is supporting organizations, law firms, in-house counsel, and supporting them in this, if you like, the scaffolding around how lawyers can be better lawyers and maintain ethics. I think that the cultural piece is also very important. And I think in the cultural piece, a lot comes down to how safe within an organization people feel to speak up. And I think investment in that is, I would put as a very high priority.
Did you have a question for the panel at all?
As I say, it was more of a comment, but
That's
obviously if
fine,
the panel
that's
has
fine.
reactions
Yeah.
to my comment, that's great.
That's fine. I would just say that I personally work very closely with the International Federation of Accountants and look with great interest at their Global Ethics Board. I think that's a potentially interesting proposal, although I dread to think of the logistical challenges of trying to create a global ethics legal board, but it would be curious. Richard, did you want to come next?
Thank you, Sarah. My name is Richard Given. I worked for last year very closely with Jenifer Swallow, who wasn't able to be here today. So I know there's a couple of points that she would probably have raised. One about the SRA and the safe point that Jeremy made about being able to speak up. And I think, Tetyana, you talked about junior lawyers. In the in-house community, the experience has been quite the opposite. If you try and ring the SRA, their default is, should we investigate you? Not, how can we help you? And I think that is a major problem with the regulatory environment for lawyers. As Paul knows, I said to him 6 months ago, I go to work every day knowing I breached the principles because I can't be independent. And the SRA say that we're a priority, but I don't know how you can have a priority when there's 25 priorities. So what do you think the SRA, the BSB, all the regulators can do to change that?
Who wants to go first? How can we change the prioritization and the issues, particularly with an in-house focus, as Richard's explained? Does anyone have a thought on that? Sophie, you've been in-house.
Yes.
What do you think about
I've been
that?
in-house, out-house, all around the house. So
Do you recognise Richard's
I
conundrum?
do recognise it, and I much prefer being out of house because of that. You can say it as it is. If they take your advice or not, that's their choice when you're out of house. And you can be much more forthright and clear, and I really feel I can do my job better. In-house, there's the swirl of the business. Could you give in-house lawyers, they will be taken out of the business for which the business will pay, and they will go out and they will be trained, retrained, reprogrammed perhaps, in relation to ethics, and then they will go back in and they will deliver that speech and their obligations to the board. That maybe, I don't think boards understand how lawyers are supposed to work. I think they are employing a lawyer, and actually they're employing a professional. And I think it's that retention of independence that I found, having been in, out and worked for myself, that I really enjoy. The legal director is very interesting because what they do, we're all experienced in-house lawyers, but are sort of rented on a daily or hourly basis for small firms. So you can get, what is perfect is getting in-house expertise, but outhouse. And so there are many different models, I think, developing in the legal industry, which can help in-house lawyers perhaps work.
I think the position of an in-house lawyer is absolutely fascinating. You're right, Richard. You go to work and you are effectively wearing two hats because you owe your loyalty to two masters. You owe your loyalty to the rule of law and your profession, and also to the person who pays your salary. And I think one thing that you need to remember, it's almost like the position of an in-house lawyer is almost like the position, constitutional position of Attorney General advising the Prime Minister. Attorney General, even though appointed by the Prime Minister, does not take instructions from the Prime Minister. He advises the Prime Minister on what is the right and lawful thing to do. And I think that's what a good in-house lawyer should be doing. They should be advising their board what is the right thing to do legally, and the board can either take their advice or not. And I mean, I had a personal friend of mine, it was an in-house lawyer in a big corporation, and she actually resigned over a particular issue that the board did not agree with her on, because she felt that carrying out the instructions of the board would have been contrary to her professional ethics. I mean, that meant that their family couldn't afford to keep paying their mortgage. But yes, those are the exceptional dilemmas that members of the legal profession are facing. And I would like to think that the regulator could be more supportive in that. I really would like to think that. Because you do, especially when dealing with things like sanctions, you have to decide, for instance, do I report what's going on because I have a reporting obligation, or do I keep quiet? And people with less moral, with less fearlessness, I guess, would prefer to keep quiet. And so to do this job, I think you have to have a strong will. I think education in itself isn't enough, because we all know what the rules are.
Okay, brilliant. I think that's an important point. There was a gentleman over here who had his hand up. Sorry, if we could go there next, and then I'll come to this side of the room. Very conscious of time. If you could really keep the questions succinct, that would be fantastic.
Yeah, I'd just like to ask about the complete disempowerment of a complainant to the Bar Standards Board or the SRA. I'll give you a very, very quick example. Rule 4.3 says that it's the barrister's duty to bring the court's attention to any relevant law, even if it's disadvantageous to their client. That is backed up with a guidance note, which says it's particularly important to do this when your opponent isn't legally represented. And the Bar Standards Board, when I say this didn't happen, they said the guidance note is voluntary. We don't have to do that. That's just guidance. It's not a rule. I point them to section A6. I say guidance is absolutely imperative. The guidance sections of the Bar Standards Handbook are compulsory. And the response I get from Mr. Paul Pretty, the head of investigations at the Bar Standards Board, is, we're not going to answer any more of your letters. End of.
So,
Now, that combined with secret appeals held by anonymous people at BTAS against administrative sanctions, which are the less important type of complaint. You either go to a disciplinary tribunal or an administrative sanction. So they fly beneath the radar, and they're not reported in the legal press. Then they're not picked up by the legal blogs. They are internal investigations by the BSB. If your complaint is upheld, and tiny, tiny numbers are, then it goes to appeal at BTAS, and BTAS in secret have an anonymous panel, and 75% of those appeals succeed. Now, who is acting in the public interest? Is it the Bar Standards Board when they issue these administrative sanctions? Are they being trigger happy? Or is it in BTAS who overturn them in secret? Because both of them can't be acting in the public interest.
I think there's a range there. Thank you for that. Appreciate that point. I think there's a range of issues there. We don't know the facts of the case, and we haven't got any time to get into it here and now. So I respect the position, and it may be worth a separate outdoor conversation to think about if there's anything more we can help you with. The question here, is it more about whether proceedings in secret are within the public interest in this context? Is that perhaps one of the points you'd like us to address?
Yeah, it's a system.
A system of secrecy.
The old police
Yeah, stacked against the litigant.
You know,
Mhm.
police are
So
put in
much
charge
just-
of investigating.
What's your experience?
So in this case, it's barristers.
Yeah. Yeah. Well, okay.
I think, as Sarah said, we can't comment possibly on the details of each individual case. Proceedings in secret. I am not familiar with that particular scenario, but certainly that seems to me to be contrary to the fact that justice needs to be seen to be done. So we generally have a preference for open justice. And one of the reasons for that is so that there is a public scrutiny of the behavior of the lawyers and the judges. And so one would expect disciplinary proceedings to be in public, and they tend to be. I mean, the disciplinary tribunals tend to operate in public.
Well, why don't we have a chat outside? Because I think there are lots of issues you've raised there, and I'm conscious we've got 2 more minutes. Okay. All right. Well, let's do that. Have we got time for one more question, and then we're literally meant to wrap up, so I don't want to incur the wrath. Okay, perhaps the lady in the middle here. Oh, sorry. Thank you.
Hello, Michaela Hardwick from Beyond Compliance, specialising in regulatory compliance. I've got an observation and then a question for the panel. We seem to be talking a lot about what regulators need to do about professional ethics. For me, what's resonated with the point that's resonated most with me today is Lee's point that we are all regulators. What does the panel think? Well, does the panel think that actually what the regulators could do collaboratively is to encourage that type of self-regulation by all lawyers and the link to culture and everything else there?
Okay, please.
Pick up quickly on that. Yes, it's been very interesting for me because I have been shocked by what I've seen about the way lawyers behave in the entertainment industry. And I did look in reporting this to the SRA, and I discussed it because the TLD has an advisor, and we are, as lawyers, we are professional regulators, as I understand it. Once I knew this, I had an obligation to report it. It's not just as a person, it outrages me, but I do have so if you don't do it, you're already breaching your own personal obligations. So I really wanted to say, and I have reported. We'll see what happens. But, and I'm encouraging agents to do, I'm encouraging everyone to do that. But I also want to say that Me Too happened a long time ago. And it's the gaze is off the entertainment industry again. As I've said, it's still going on, but because of Lee and because of post office issues, the paint is wet. Now is the time, we have the public support, and now is a really critical and unique time, I think, where we can regulate with the support of the public. So
yeah, I was
my
just going to say,
soapbox.
I totally agree with you. And I just think some of these issues are so deeply embedded in the mentality of the legal profession. And I think there are certain assumptions that it's perfectly appropriate given our adversarial model. I think there's a couple of examples of that. When I started getting involved in SLAPS in 2016, working for Greenpeace International because of a lawsuit that was filed against us. And the law firm that filed that lawsuit, their tagline was "creative, relentless, aggressive." And the website they had all of these images of people preparing to go boxing. There was another good example that Richard Moorhead gave last year, I think, in this conference, which was of a website which said of a lawyer that it was a steamroller that crushes anything that gets in his way. You know, so it's like that type of thing which is really need to be embedded, and we need to try and challenge and to reverse on that deep cultural level. And I think that does take some regulation as well as.
Okay, I'm having cards thrown at me, so shown in the background basically, but I was invited to ask regulators to respond. Did any regulator in the room want to say one sentence in relation to what they may or may not have heard or their observations at all? Anyone want to say anything? Can't put anyone on the spot because I can't immediately spot an immediate regulator.
I know with the regulators
All right.
at the end today, so you may well be just gathering your thoughts and bringing everything together. Sara, your panel, thank you so very much for taking us through this. Now, before you leave, can I just bring Gabby in here? Because obviously, and I was saying, it's no good shouting all because people online cannot hear you. So please don't raise points without microphones. But Gabby, what are we hearing through online audiences?
There's a lot of supportive comments, particularly around the role of whistleblowing, particularly for the lawyers early in their careers. How do we make sure that there's appropriate employment and regulatory support for them to raise concerns, or perhaps when they can speak up rather than needing to whistleblow? Also, the conversation around ethics being something that you think about after something's gone wrong and it being a catch up, as opposed to something that should be at the forefront of what we do. And just generally, how do we empower lawyers to be their best ethical selves throughout their practice?
So I can see Alan absolutely is taking that on board. So we'll expect to hear more from Alan later. Thank you so much all. A long session. Thank you so much to the panel. Thank you so much to the speakers from this afternoon.